Hello everyone, this is CS Priyanka from CS Priyanka's Profession Classes. Welcome to my class. And again, I am here with a new topic, with a new three topic under the Indian Contract Act 1872. Today we are going to discuss the three topic. One is quasi contract, second one is contingent contract, third one is contract of indemnity. Okay, I have prepared these notes and I will try to clear your doubts and will make it very easy for you for your understanding purpose. Hope you will like it. So let's get started. So first, let us start with the quasi contract, which is coming under section 68 to 72 of Indian Contract Act 1872. Okay. So quasi contract is coming under section this, okay, 68 to 72. So what quasi contract is telling, let me read this, then I will explain you in my own words. An obligation that the law creates in the absence of an agreement between the parties. Quasi contract is a contract that exists by the order of a court, not by the agreement of the parties. Actually, quasi contract arise in absence of actual contract or agreement. Okay, in absence of actual contract or agreement. That means you don't have any type of legal agreement or contract beforehand with anyone. But suddenly, certain situation came where automatically some responsibility came on you. Okay, and you are liable to perform those acts. That means what, suddenly that contract came in absence of actual contract, means suddenly law creates in absence of actual contract. Got it? So actually there was no contract, no agreement between no any parties, but suddenly due to some situation came. Due to that, you are liable to perform your work and law creates instead. Got it? That is quasi contract. So for better understanding purpose, we are going to discuss some of the examples. See, some of the quasi contract discussed in the act. I will explain all these things between section 68 to 72. But before that, I can tell you one example. For example, think suddenly uh, you found a wallet in road or in the public vehicles like that. Okay, so you are traveling in a bus and suddenly you saw just beside you a wallet is there. Okay, so the person who left, okay, just before some time he left the wallet there. So being a human being, what you should do, you should check the wallet whether you get any number or not, so that you can hand over this wallet to the actual person. Or else if you can't, it's your responsibility to submit in the nearest police station, so that that person may have a lot of cards there. So just to help that person, being a human being, I'm not telling like you have to do or every person do that. Got it? It's your etiquettes, your, you can see it's a ethics, your moral values. Got it? So now this is, till you didn't found wallet, no contract was there before. But when you found this wallet, suddenly some responsibilities came on you that you have to return this wallet to the actual person. This is actually the quasi contract. So for better understanding purpose, I'm telling, like suddenly you are passing through a road and suddenly you saw one accident made in front of you. Being a human being, what you should do? Okay, till that period you have no accident happened, no contract was there, existing no contract was there. But suddenly when you saw some accident made in front of you, suddenly some responsibilities will come on you, that you have to admit that person in the nearest hospital, or else you have to inform the police station. You should, being a human being, you should save that person, you should help that person. That is quasi contract. That means actual contract or agreement is not there, but in absence of actual contract or agreement, suddenly some law creates, like some responsibilities will come. That is actually quasi contract. Hope it is, I think now it is clear to you. Now let us discuss, it is discussed in some situation between the section 68 to section 72. So let's see, section 68 is telling, claim for necessaries supplied to a person incapable of contracting or his account or on his account. For example, the actual person, okay, for example, the actual person um, is incapable, sorry, is incapable or inefficient to contract. Okay, it doesn't means like it doesn't means that this person is inefficient, means he is not capable of doing anything due to some reason, but maybe he's sick. He is maybe sick, bedridden, he is in hospital, okay, he is in coma, anything can happen. So currently this person is not capable of entering into a contract or not capable to do any act. Got it? In such cases, you can act on behalf of this person by taking the authorization from this person. Okay, so claim for necessary, you can claim. For example, think he is supposed to get some thing, or see, he is supposed to submit some papers to his office, okay, for the reimbursements of some money, but though he is sick and incapable to enter into a contract, you are helping him, that on behalf of the actual person you are claiming the amount or his amount of reimbursement from the office. So these type of things, like you don't have any obligations until he's telling something to you, but as soon as you saw like this person is not capable of entering into a contract, you wants to help him, so you wants to claim the amount on behalf of this person. So this is coming under section 68. Next is section 69. Reimbursement of a person paying money due by another in payment of which he is interested. Okay, it's the same like things. This is like necessaries. I'm talking about goods. For example, necessaries supplied means he cannot take those goods as he is incapable, or he's not means he's sick, or he is incapable of taking these goods or necessary things from anyone, and on behalf of that you are helping that person to taking the goods on behalf of him. That is 68. Now we are talking about the reimbursement of person paying money. For example, the person is supposed to reimburse some money from anywhere, so due to some reason he cannot come, maybe he is sick or he cannot come, so he is authorizing someone. For example, you are the person who is, he wants to take the money, okay, money of reimbursement on behalf of him from the office and all. So this reimbursement of payment of any money, whenever you are taking on behalf of another person, actual person, and you will take and you will give to him only, this situation is coming under section 69. So 68 is about any necessary goods or supplies, whatever is supposed to get. If I am sick, so I will send my sister or my friend, he will go and collect it on behalf of me. This is coming under the situation 68. 69 is reimbursement of money. 70 is obligation of person enjoying benefits of non-gratuitous act. Okay, so any person, any obligation means a person's responsibility to enjoy the benefit of non-gratuitous act. Now, that means whenever any what do you mean by this, what to say, what do you mean by this non-gratuitous act? For example, think you have obtained any, you have given any charge or fees, you have taken any charge or fees or payment, any voluntary amount, okay. So these are the, as per law, whenever you are receiving any you are giving anything to someone without without any intention of receiving any return, Got it. That is non-gratuitous act. So gratuitous act, I can say you, for example, like you are taking loan. Okay. So whenever you are taking loan, you have to pay this loan along with the interest. That means the person who is giving you loan, he is taking the loan along with the interest. So he is having some return. Got it. Non-gratuitous means you will give something, but you are not going to take any return. That is. So whenever you are having, for example, I can give you one example under section 70. Okay, any person have done for you during your bad times. Okay, whenever you are in a very bad condition, that person helped you. So it is your responsibility, it is your moral values, like whenever he will face any problem or he is in trouble, you should help him without means without expecting any type of returns. So this is like this is your responsibility. I'm not telling like every person should do it, but it's your moral values or ethics, you can say. So it's a responsibility. It means someone is helping me in my trouble times. Whenever I'm in trouble, someone is helping me like anything. So it is my responsibility to help that person whenever the time will come or time comes, whenever that person in trouble in like that. So I can't expect that I will get some return from that person. I will remember that day when no one was there with me, but that person helped me. This thing is coming under section 70. Now come responsibility of finder of goods. Suddenly you found someone's good. Okay. So wallet is one of the example. Other example you can say like by mistake you got some delivery. Got it. Like you ordered some food through Swiggy, and by mistake Swiggy delivered into that food to the next door. So it's a responsibility of your next door people to return it to you, not to eat that. Got it? Because you paid it. So whenever you receive or find any type of goods by mistake which is not yours, so it is your responsibility just to find out the actual owner. Okay. And lastly, 72 is telling liability of the person to whom money is paid or thing delivered by mistake or under question. So it is means this is also same like before also, like whenever you are uh, delivering means liability of person to whom means by mistake I received some goods, by mistake I received the payment, by mistake I received something which is not mine, by mistake it came, so it is my responsibility to return it back to the actual owner, actual person who is supposed to get that. So this is the liability of the person. So until and unless I received it, no responsibility, no contract was there. Suddenly when I receive such lump sum amount by mistake in my account, it's my responsibility to talk to the bank or to search it out who is the actual owner. So I should return it back to the actual owner. So that is the liability of the person to whom the money is paid or things delivered by mistake or under question. Question means it's under threat or fraud like that. So section 72. So if you read nicely, so it will be clear to you, like from 68 to 72 is telling you like liability or responsibility of a person when he is not supposed to get the actual things, but he is getting by mistake, or he is getting no actual contract or agreement is there, but it is there some responsibilities coming on him due to some situation. So what he should do, that is quasi contract. Next is contingent contract. The term contingent, I can say, may happen or may not happen. It's very uncertain. That is known as contingent. You didn't know whether it will happen or it won't happen. I can give you one example like life insurance. We are paying the premium. Why? Okay, whenever we will die, we will get the amount. So I cannot assure from now like when I am going to die, right? So this is a contingent contract. That means you are not sure about the situation whether it will happen or not, it will happen or will not. So I cannot assure you from now. It's a very uncertain in nature. That type of contract is called contingent contract. So for example, any type of insurance, for example, like I can say you, like whenever we are doing insurance, car insurance, okay, so whenever the car will meet an accident and will damage, I will get the insurance amount. So that I don't know whether in this year my car will damage or not, or I will meet an accident or not. This is very uncertain in nature. It may happen, may not happen. That type of contract is called contingent contract. So contingent contract is a contract to do or not to do something. If some event collateral to such contract does or does not happen. Example, A contract to pay rupees 10,000 if B's house is burnt. So it's very impossible and uncertain. Okay. So A contract to pay B, I will pay you 10,000 if your house is burnt. How can you assure that your house will burn today or tomorrow? You can't, na? So these are all contingent contract and impossible. So these are void. Some essentials are there. The essentials of contingent contract are as follows. It's a totally uncertainty and futurity of the event to which it is related. It is uncertain. You don't know, it may happen, may not happen, and is all linked with the future. In future, whether when it will happen or not, you don't know. Okay, so it's uncertain first of all, and it's it is going to be happen in future. An uncertain future event must be collateral to the contract. Okay, in future it will happen or not happen, it will happen or it will not happen, it's we can't say from now. So it is some impossible event. So this type of contract, if you do, it's a contingent contract. As an impossible contract also, we called it void. Next is reciprocal promises are not contingent contract, as they cannot be said as collateral to each other. So obviously not. What do you mean by reciprocal promises? You know, like I am offering you something. I am offering you that I will give you this property. Instead of that, you have offered me that you will pay me money or you will give your flat of same value. So this is reciprocal promises. So here to instantly we are promising each other something. It cannot be contingent contract. So maybe I will transfer you in future, but the contract is valid one. It's not impossible contract. That's why any type of reciprocal promises is not contingent contract. Contingent contract is not independent on any external event. It may be conditional on the voluntary act or the future conduct of one of the parties or third part person. So it is not an independent, means it is not independent act. That means we don't even know. For example, you can say one car is means your goods is coming in this car from Mumbai to Bangalore. If I'm telling from Mumbai to Bangalore, now this is contingent because you don't even know whether this goods will come safely in your hand or not. In road, if it made this car made an accident, or it you may like the goods may destroy, right? So it's a future it's not independent. So what will happen, it depends on many things we don't even know. Okay, so it's act of God or anything can happen. So it's not independent, it is dependent on the situation whether your contract will become contingent or not. If this goods comes in your hand safely, we can call like this contract is not contingent, this is okay. In case if they made accident in the road, so obviously this contract is a contingent contract. And if agreement contingent on impossible event is void. So impossible event, I already said impossible event means the event which is not possible you to perform, possible for you to perform. For example, just now I said, like for example, I am telling you like um, I will give you 10,000 rupees if you die, or if you kill, I will give you 1 lakh rupees if you kill Mr. B. So these are all impossible event, you should not do it. Okay, so illegal. So if I'm offering you some impossible event, if you do this, then I will give you this. Okay, so obviously it is not possible for you to kill someone to get 1 lakh rupees. So these type of agreements are totally void, and void means illegal. Two example I have mentioned. A makes a contract with B to buy B's house if A survives C. This contract cannot be enforced by law until and unless C dies in A's lifetime. Got it? So A is making a contract into a B. Uh, for example, I am A and you are B. I am telling you like I will buy your house. Okay. If you survive C. Got it? So this contract cannot be enforced by until and unless C dies in A's lifetime. Got it? So if C suddenly dies in your lifetime, so obviously this contract will become void. So these are all impossible event and contingent. Next is A contracts to pay B a sum of money if B marries C, and C dies without being married to B. So before marriage only C dies. So how the contract will become void automatically? So these things are known as contingent contract. Next come contract of indemnity. What do you mean by the term indemnity? Indemnity means compensation for damage or loss. Basically, for example, if I face a loss due to you, then as per law, you are supposed to compensate me, to pay me the damage amount or the loss amount. Okay, so if I go to court, the court will also ask you to pay me the loss amount or damage amount, what compensation, to compensate me by paying me the loss or damage amount, whatever I face due to you. Got it? That is known as contract of indemnity. So like indemnity is compensation for damage or loss. So for example, like if A is suffering loss due to B, then B will compensate A by paying the compensation for loss or damage. This is known as contract of indemnity. So obviously it's the agreement between two parties. Here one party agrees to pay to other party, means the party who will face loss, that party will take the amount from the other party who is liable for such loss. Got it? So here one party agrees to pay for the potential losses or damages caused by the other party. Now this contract constitute two party. Okay, one we called it indemnifier, other one is indemnity holder. So what does this mean? What does this means? The person or a person who promises to indemnify from losses is called indemnifier. Got it? And the person whose loss is made is known as indemnity holder. So for example, like A and B. Who suffered loss? A. And who is going to compensate? B. Pay compensation. So who will going to compensate? B. In this situation, who will pay, who promises to pay the loss? B. So B will be known as indemnifier. And to whom the loss will be paid? The person who faced the loss. Who faced the loss? A. So A will be known as indemnity holder. Okay. Such contract of indemnity may be either expressed or implied. Okay. So express means, you know, whatever is written in the contract, according to that we have to follow, we will follow. And what is implied means what? Like you are liable to do something. Okay, for that is implied. Nothing is written, but due to your act or conduct, it is clear like what you should do. Suddenly we met an accident in the road. So obviously, na, suddenly you made an accident. So whenever you are liable for my loss, you will pay it. No existing contract is there, but instantly the contract will be made on the basis of your conduct and act. That is implied. It was held that almost all the insurance other than life and personal accident insurance are contract of indemnity. So actually life insurance is like of contingent, because you don't even know whether we will die or not and all, etc, etc. But normally all other insurances like phone or any type of car, etc, etc. So what happened when we made damage, when we means, made an accident, or when we suffered any loss and all, we get the insurance amount. So that already is existing contract was there between us, like when we will face the loss, they are going to compensate us. Obviously we have paid them. Okay, means we have paid there, but at the time of emergency we are going to get from the insurance company. So this is also a time of indemnity, like whenever we will face the loss, the insurance company is going to compensate the loss by paying the amount. So that is also coming under the contract of indemnity. So one case law I have mentioned, Goldstone Discounters versus Clark. This is a popular case law. In this case law, two person like A and B went to a shop. Okay, B say to shopkeeper that let A have the goods, I will pay you. So if you see from, if you interpret this case, then you it will see like that ki B said to shopkeeper that a shop, okay, B said like it's a shop. B said to the shopkeeper that A will have the goods. So A will take the goods from the shop. Now, if you see up to this, then you will see like shop is facing the loss for the goods, whatever is taken by A. Okay, that loss is going to be compensated by B, because B said to shopkeeper, let's A have your goods, I will pay you. That means one person is taking the goods, other person is paying it. So due to A, whatever loss the shopkeeper suffered, all will be compensated by B. B said like that. So this is also a contract of indemnity. Got it? So one person suffered a loss due, okay, and I am going to compensate that person. This is also indirectly it's a contract of indemnity. So thank you. Hope I have made a bit easier for you people to understand the basic things, and books, the reference books are obviously there. You can refer those, and but for understanding purpose, I think it's clear to you. For in case if you're having any problem, you can write in my comment section. I will clarify. So, thank you, and requesting you to do all the videos under the chapter Contract Act, which I have shortlisted under the playlist. I have made the playlist of Indian Contract Act. And if you like it, don't forget to like, share, and subscribe. Okay. So, bye. See you soon with the next video.